Let us pray. Almighty God, the creator and ruler of heaven and earth, we beseech thee to inspire and guide all our actions so that we may always walk in the path of justice, love, and charity to one another. Help us with thy grace to do only those things that promote the unity, peace, happiness, and prosperity of Nigeria in general and Lagos State in particular. Amen. Good afternoon, distinguished colleagues. You are all welcome to today's sitting. Let us go through the votes and proceedings of Monday, 27 July 2020. Page 195. Page 196. 197. I have examined the votes and proceedings of Monday, 27 July 2020, and approval is granted. Any message from the governor?
Right, Honorable Speaker, distinguished honorable members, there is no message from Mr. Governor.
Any other announcements?
Honorable Speaker, sir, we have a correspondence from the Office of the Attorney General and Commissioner for Justice addressed to the Clerk, Lagos State House of Assembly, the Secretariat, LSHA, and it is titled Contribution of the State Executive into the Proposed Amendment of the Lagos State Transport Sector Reform Law 2018. With your kind permission, sir, I'll read. The above subject refers, Please find attached the contribution of the Lagos State Executive into the ongoing review of the Lagos State Transport Sector Reform Law 2018. The amendment is necessary to separate transport from traffic management, since both are not necessarily the same, and one thing as contained in the Eastern law. Transport is generally related to the carriage of people or goods from one place to another by means of vehicle, aircraft, or ship. This excludes a large number of road users who are private owners in charge of their vehicles and who are not conveying goods or people and are only concerned with traffic law. The review also attempts to address some of the problems associated with the implementation of the law in order to make it more user-friendly, and bring it up to current realities in traffic management in line with global best practices. Kindly consider and incorporate the contributions as attached into the ongoing review of the Transport Sector Reform Law 2018. Please accept the assurances of our warmest regards. Signed, Mr. Muyosore Jubri Onigbanjo, SAN, Attorney General and Commissioner for Justice. I also have this. There will be a day public hearing on Lagos State Lotteries and Gaming Authority Bill 2020 by the Committee of Finance on Friday, 14th August 2020 at the House of Assembly Pavilion, Assembly Complex, LSHA Ikeja by 12 noon. Please be punctual. Thank you. Signed, Honorable Olowo Rotimi, Chairman, Committee on Finance. Thank you, sir.
Petition.
None, Mr. Speaker, sir.
Matters of urgent public importance. None. Personal explanations. None. Reports. None. Business of the day, majority leader.
Mr. Speaker, distinguished colleagues, good afternoon. On the other paper, we have House of Assembly Bill number 10 listed for second reading. May I, with the permission of the Speaker, move that the Lagos State Public Procurement Agency Amendment Bill 2020 be read for the second time. I so move.
Honorable Desmond Oru.
Thank you, Right Honorable Speaker. I rise to second the motion as moved.
All in favor say aye. Those against nay, the ayes have it. Mr. Clerk.
Right, Honorable Speaker, distinguished honorable members, it is my honor to read for the second time a bill for a law to amend the Lagos State Public Procurement Agency Law, CAP L56, Laws of Lagos State 2015. Thank you, sir.
So who goes first? The Honorable Shaw.
Good afternoon, Mr. Speaker. Good afternoon, colleagues. The bill for an amendment of the Public Procurement Agency, which has just been read for the second time by Mr. Clark, I think it's a welcome development, even though I'm sure this House has worked on something extensively, but this is very welcome because procurement is very important in development of a nation, especially a state. And quite a number of people have, over time, even at the national level, complained about the procurement laws of the country, including the ones of the state. So anything anybody can do, especially the Lagos State House of Assembly, to ensure that procurement is seamless, easier, without compromising the accountability, probity, and transparency that it's required, is a welcome idea. And looking through this particular amendment, I'm happy to see some things there the issue with respect to removal of the GM, which was subject to the House of Assembly. I also have areas whereby tenure is addressed, tenure of members of the board are addressed, or is addressed. We also have some areas that I think are no-no, because I found somewhere where the bid document, the approved budget to be removed totally, which I don't think should be the way, because the budget is a public document, and the fact that somebody said that if the budget accompanies the bid document, the person will know how much is going to be spent on the product or the contract. The budget is a public document anyway, so anybody could have gotten that. Most people even get the budget before they apply for those contracts. So, but it is important because the public procurement agency is the gatekeeper of the budget for the House of Assembly. So that is very, very important. So for me, I think it's a good bill. It's a good bill to ensure we have procurement law that is in tune with the times. And I would urge my colleagues to support that the bill pass through the second reading, where a committee can do justice to it. Thank you, Mr. Speaker. Okay.
Honorable at the back, who is that? Not you. Honorable Sulaiman.
Hello. Thank you very much, Right Honorable Speaker. My distinguished colleagues, I am very happy that this bill or this law is about to be amended, because there are several issues that are detected that are associated with the bill. But with the way it is now, it is clearly shown that once this bill is amended and passed to law, which is 2020, I am convinced, and I want everybody to be convinced, that the process of procurement will be very smooth. Procurement as it is, because when we look at it critically, we discover that there is nothing like development without procurement. The essence of capital budget, it is on procurement. And it is on procurement that the level of development of every country, as well as states, is measured. This is why the World Bank emphasized on the establishment of procurement department or agency or organization or tender board in our ministries, parastatals, and so on and so forth. And along with this, there are guidelines that we are supposed to follow, because day in, day out, we get bonds, we get assistance from World Bank, and World Bank is an organization that is particular about whatever amount they spend. So in the light of this, they made it mandatory for all nations that certain areas are supposed to be followed before they can release their own fund. That be as it may, in our own case, talking about our budget and so on and so forth, budget cannot just be spent without laid down procedures, which has to do with procurement as well. So as a matter of fact, I want to enjoin my colleagues that this is a very, very important thing. This is a very, very important law that if we put our heads together, I know we have digested it. I know we are in terms with what are listed there. The essence of it is to enhance smooth procurement plan and procurement process. The idea of work is not done is taking this, taking that, talking about the bureaucracy I believe with the amendment of this law, all this will come to pass. For instance, Section 33 of this law talks about, excuse me, sorry, talk about advertisement period. Before now, it was within 6 months, 6 weeks, but it has been reduced to 4 weeks now. The reason being that there is need to make the process faster. So if you are, as a bidder, if you don't comply within the period stated, it is your own, it means you are not responsive. That is that. Then Section 18, which talks about the removal of the general manager. Now it has been brought, it is proposed in the law that without the concurrence of the House of Assembly, the general manager cannot be removed. Let us look at the importance of this. It means an executive power cannot just be passed on this without the whims and caprices of those that are concerned. So it makes it so accountable, and it makes the process smooth in the sense that even the general manager too, we know that is on top of his job. And of course, nobody can just come out and say, hey, how are you doing it? It is not like that. Another area I want us to look at is the Section 30, which talks about the accounting officer of every ministry or parastatals. The power is vested in the accounting officer. It could be the permanent secretary, it could be the general manager or MD. But in addition to this is the involvement of local government and SCDAs. They are all incorporated in this particular law. Before now, they were not mentioned, but now they're expressly mentioned. I wouldn't want to be mentioning because I know we are all prepared. I just want to enjoin us that with your efforts, without wasting time, with your ingenuity, without wasting time, but I believe by the time we put heads together and this proposal becomes law, by the grace of God, Lagos will be better. Thank you very much.
Who has the light at the back?
Good afternoon, Mr. Speaker and my colleagues. Well, I think the Ministry have done a lot of justice on this procurement law, CUM amendment. And let me sincerely support what the Honorable Shaw have said and the chairman of the committee, Mr. Honorable Age. But for me, I believe the auditor do the post-auditing, while the procurement do the pre-auditing. Pre-auditing in the sense that following by the monitors and budget that has been approved by the House of Assembly, this particular law is explicitly enough for anybody that derives from it so that we can handle them with care, so to say. But I believe honestly with e-procurement activities and e-procuring is a different entity. Procurement is a global, while procuring particular items, and it has been stated in this law. That is why I've said they have done justice to it, and without missing any word, I give kudos to them. Thank you, Mr. Speaker.
Honorable Tabo.
Thank you, Mr. Speaker. Well, PPP, I join those who are in support because it will bring transparency and it will bring standard in award of contracts to consultants or would-be. But there are some observations that I noticed in this bill that I may want clarification before we pass it. For example, Section 2, number 2, amendment to Section 9. When you look at amendment to Section 9 and amendment to Section 15, in the old law, Section 15 is staff regulations and pension. And the content, principal law is deleted and renewed with consider the review and recommendation of monetary benchmark. In the old law is section 9, subsection 1. So we have to look and ensure that proper section is quoted. Thank you, sir. Then furthermore, in section, that is number 5, section 18, 18.4, we have to say without prejudice to the provision of section 3 of this section, the general manager may be removed from the office by the governor, subject to the approval of the State House of Assembly. Sincerely, sir, I feel there are some general managers who were career officers. And I feel if by the time you start subjecting them to the removal, it may encourage red tapeism for those who did not live up to expectations. Sorry, sir. Furthermore, number 12, amendment to section 31. Where they said the political head of the procurement unit shall be notified of the decision of the tender board. And in the previous section, it has been clearly stated that the procuring, the chief executive or the accounting officer of the procuring entity is the chairman of that procuring committee. So what I'm just observing here is there is no option for appeal in case if the tender board, by way of omission or commission, throw that report into the dustbin for the reason best known to them. There's no provision for appeal or representing it before the tender board. So that means the decision of tender board overrides whatever the committee might have done at their level. Then number 14, section 33. 1433, subsection 2. So the 3.1 said, if you are building at international level, you put at the national papers. But if it is a national competitive bidding, I equally of the opinion that the national dailies, it must be publicized in the national dailies. It involves national competitive biddings. So at least 1 or 2 of the national dailies will suffice. Like not putting it there, I feel if it's just on the board of the procuring entity, not many bidders will be informed. Sorry, Mr. Speaker. Furthermore, sir, number 33, section 63, where they said, advance payment of no more than 40% of the contract sum may be paid to a supplier or a contractor. The provision behind is that, provided that the advance payment above 40% shall be subject to the regulation prescribed by the agency. That means the agency can vary the advance payments to be paid to the contractor. So, and we have observed in the past where some contractors were paid as much as 70%. And what they end up doing is to bolt away with the government fund. And become so difficult for us to track them down. So where they now put punishment, that imprisonment for 2 years of a fine to be paid, of an equivalence to be paid, to have been paid. I feel if a money has been paid to a contractor and the contractor failed to perform and he has been arranged, apart from prosecuting him and sentencing him to a sentence, if he has to pay the money back, it must be paid with prevailing interest. Because if you have collected the government money for 2 years in your possession and you are prosecuted, you are taken to court for prosecution and you are asked to pay back that money, that means one can collect government money, keep in savings, in what do they call it, and collect interest on it and later pay back. So I feel it should be paid, the punishment should be either sending them to prison or should pay back with interest rather than paying the money back as it collected. Before finally, sir, where they said, sorry, sir, section 32, that is a 3.3. In the case mentioned under paragraph 1 and 2 above, The tender board may accept other form of security which is considered sufficient to guarantee performance. The question of what other form of security do we want to collect when it has been clearly stated that APG or bond could secure our fund. So if you now give the agency laxity to consider other security, I think those security, apart from putting it in their regulation, we must know so that what we consider sufficient may not be sufficient to guarantee the security of government fund. So when money will have been released to the contractor at the instance of the contractor. So thank you, Mr. Speaker. That's my contribution.
Honorable Satonji. That's Honorable Speaker, my colleagues. I appreciate this amendment to a great extent. I'm particular about two sessions which have been well addressed by my colleague, Honorable Tomo. But my concern is that before now, according to Section 32, Subsection 1, that it was 20%, and the challenges we had with the advancement of 20%, they slowed down a lot of projects. So increasing it to 40% is a fantastic idea, which this bill has suggested. But further down, it said, provided that advance payments above 40% shall be subject to the regulation prescribed by the agency. As addressed by my colleague, that is the loophole that the former administration abused to the extent that some contractors were given 90%. I think we have to be precise based on our past experience to ensure that we limit the advance payment to 40%. I don't give them the discretion unless another body will consider it instead of the principal giving them ordinary instruction that, okay, give the contractor 90%. We have cases of that in several awards during the last this thing. So I think we have to look into that very much so that we don't make the same mistake again. And lastly, as addressed by my colleague, Section 32(3)(3), Section 3, Subsection 3 again, in cases specified under paragraph 2 and 3 above, the tender board may accept other forms of security. My colleague has addressed it. Sir, that area is also very key. We are giving discretion to the agency, and they have abused it in many awards. I think we need to reconsider this particular section. Thank you, sir. Honorable Laiwola.
Good afternoon, Mr. Speaker. Good afternoon, my colleagues. I join my colleagues to say this bill is a good bill and is a timely one and is equally a reasonable bill. This bill, when it's enacted, will help to establish far-reaching acceptable procedure that will ensure compliance with applicable laws, executive orders, circulars, and ministerial mandates, as well as outline responsibility for the execution of projects as defined. Mr. Speaker, sir, looking at Section 20 of the bill, which has to do with accountability, I support the proposition there because it will ensure, it will enhance good governance, it will enhance due process, and accountability as well as feedback and embracing international best practice in governance. Sir, this bill will also guide our ministry, department, and agencies from concept of a project to closure of projects. It will also ensure strict compliance to all stated terms and conditions in the procurement document, sir. All that I'm saying is that this bill will define the role and responsibility of each stakeholders in procurement procedure. However, I align myself with what my other speakers have said, the observation that they have made in respect of Section 33, subsection 2. This will give room for investment of funds. So we need to critically look at it. Then section 32, 33, subsection 1, that has to do with limitation, as rightly put by Honorable Tobo. Honorable Secretary needs to be looked into, sir. I support the bill, and I'm in total support of what we have here. Thank you, sir.
Honorable, good evening.
Thank you, Right Honorable Speaker. Good afternoon, my colleagues. Well, I want to agree with most part of the section of this newly introduced bill. I will speak to just three things. Well, I think the amendment of section 18 is a welcome idea, because the office of the General Manager of Procurement office should be guaranteed, because of the sensitivity of the work. Cannot be just been hired and fired by the executive. That is very important. And the aspect of the section 32, that is really been amended. Also, that is section 63 being amended. Well, I think regulations should not actually supersede the main law. The condition being given in that section 1, provided that the advance payment above 40, there is a reason for us to take the advance payment to 40 in the amendment bill that we first ratified in the House. And that was due to the lot of uncompleted projects within the state. And coming up, even in that one, we stated that there are some special projects that could be given some attention in terms of increasing the percentage. Well, it should be well spelled out while making this law. It should not be left in the aspect of the agency regulation or requirements, because that will be an hidden agenda, and its regulation cannot work outside the law. Lastly, you mentioned something very important, and that is this project supervisor. Whoever that is managing the project as an officer in the ministry should also be responsible for whatsoever thing they are really appending their signature to. Whatever that happens to the project after a period, they too should be accountable, and the law should take care of that. Thank you.
Honorable Low.
Thank you, Mr. Speaker. I'm happy to be with you again after my sabbatical leave. Mr. Speaker, we all know that procurement is the heart of governance. And I see this amendment as a good development in the sense that, number one, it's tried to decentralize procurement. One of the amendments spoke about having procurement planning committee, which the chief executive officer should be a member of that. Then the head of the unit should be part of the planning committee. It allows for supervision. And generally, Mr. Speaker, part of the amendment as well talked about advertisement. There I may differ a bit, because when you're talking about international competitive bidding and you're talking about national competitive bidding, we should be conscious of the fact that local government is inclusive. And there are some projects that when you look at the cost itself, it might not be more than 1 or 2 million naira. And you know that any amount over 500,000, according to the law of the house, should go through bidding. And for such, we should be able to have a benchmark in terms of monetary benchmark. That if it's above this, then you can say it go for national advertisement or using 2 national newspapers. But if it's below that, then at times the cost of advertisement might even be more than the project we are emphasizing. So we should say maybe just having a notice board will suffice. Mr. Speaker, section 48, I think it allows for a lacuna. Where I say the agency will now determine the variation from 3 months, that is statutory. And we are not given time, it is not timed. They can leave it in perpetuity for any reason. If it varies from 3 months, it should not be above 6 months, so that we can have value for our money. And generally, sir, my colleague, this is a good one. The amendment has actually answered many questions, and I know by the time it gets to the committee level, there will be more work that will be done. So I crave your indulgence to let us have express approval and get it committed to the necessary committee. Thank you and good afternoon.
Yeah, Majority Leader, lastly.
Thank you, Mr. Speaker. Going through these amendments, it will be seen that this bill, one of the intendiments is to simplify the narration of the intent of the law as it stands, because a lot of the amendments there takes care of removal and substitution of some technical words used. So when you read it together, you will see that it makes easy reading and easy comprehension. Another reason, Mr. Speaker, why I'm supporting this bill is that it will strengthen the public procurement law, which major issue is contractual agreement on how to execute projects and the rest of it. In case of litigation, no ambiguity, clear narration will assist to strengthen the law. Mr. Speaker, particularly, I find useful the new section 63(2), which tries to solve the problem of abscondment of contractor after assessing mobilization fee or not performing the contract to standards. Section 63(2) criminalizes such tendencies, in which case, if you assess mobilization fee and you abscond, it's now a criminal offense for which, if you are liable on conviction, you go to 2 years imprisonment and you will refund the money so collected, and you can even have the penalty of the two. Mr. Speaker, this will put the contractors and service providers into serious caution in the state to ensure that contracts and services are delivered as specified in the contractual agreement, and of course, we won't have abandoned projects in the state without serious and dire consequences. Also, Mr. Speaker, I find so useful in this amendment the clear stipulation of conditions for advance payments. With all of this, Mr. Speaker, I am supporting this bill, and I pray it succeeds this second reading stage to proceed to the next stage, and very soon we shall see this bill becoming a law. Mr. Speaker, thank you very much.
Yeah, I want to thank you all for your contributions. I also support your views on this amendment. But there's need to call our attention that before now, the House came up with the amendment process to the same law, which has been sent to the governor for his assent. But up to now, the bill is yet to be assented. So what I will suggest is for the chairman as Committee on Procurement to take a copy of the amendment proposed by this House and the one brought by the executives side by side with the main law, so we can look it, side by side and see what we really want to do, what we have reservation for in the amendments. So that area I want us to pay attention to, because we have sat strong energy and time to get to that stage. So we can't just push the efforts of the House away. And also my reservation about the new amendment proposed, it's like taking so much out of the law. The spirit of the law being taken out and given to the agency in the name of regulations, and so that we have to be very careful about. So if you are giving, even though we have Lagos State regulation amendment, or what do we call it, law. So it's not enough for the main law to have its own spirit sustained. So giving everything to the agency to decide, we watered away the importance of procurement. The essence of the procurement is to eradicate corruption and ensure due process in contracts awarding process. So I think we have to keep to that. The time saving is very essential. I mean, reducing the period of publication for interested parties. And someone said international advertisement. Well, I think anything for Lagos should come, people in the state should be considered first, or most especially those that apply their trade within the state. Because these are the category of people that pay taxes and others to the treasury of the states. And if you have to make it international, so you are inviting everybody all over to apply for the same thing. So I think protection should be given to our own before considering. So that's how I will suggest the committee look at that area critically and come up with an idea that can be used. Well, I think the initial payment for the contractor, we have addressed this before. I don't know what our position in our own amendment, but we have to consider it. The fear was that even a little first payment will affect the process, the time to complete such assignment. And in the process, we consider the exchange rate, how Naira is being affected regularly now. So we don't want the contractor to now come back and start soliciting. So if you have to consider something substantial that will help such contractor in performing assignments given. So we hereby commit the bill to House Committee on Procurement to report back in 2 weeks. Yeah, Majority Leader. I'm sorry, Majority Leader. Honorable Desmond, what happened to your marks? Yeah, go ahead.
House of Assembly Bill number 11. I wish to move that Unlawful Society and Cultism Prohibition Bill 2020 be read for the second time. I so move.
Honorable Majid, am I right?
Yes, sir. Thank you, sir. I rise to second the motion as moved.
All in favor say aye. Those against nay, the ayes have it. Mr. Clark.
Right, Honorable Speaker, distinguished honorable members, I wish to read for the second time a bill for a law to provide for the prohibition of unlawful societies and cultism in Lagos State and for other connected purposes. Thank you, sir.
Majority Leader, your light is on. You are not ready. Go ahead.
Speaker, this is a very good bill that has come at the right time when issue of cultism, related activities, gangsterism, gang war, and other violent tendencies are fast developing across Nigeria, and Lagos not being an exception. Mr. Speaker, before now, cultism is noted to be something peculiar to campuses of higher institutions. But the decadence has taken it into our streets and our communities. Therefore, the law before now on cultism is restricted to activities within the campuses with intention to check-in it. But this bill, with the intention, is to capture other cult activities both on the campuses and outside the campuses. Mr. Speaker, I am supporting this bill because it makes provisions for defining in a large pattern what is cultism and what constitutes unlawful societies. However, Mr. Speaker, the intention of this bill does not entirely capture the spirit it tends to protect. Because in Section 3, Mr. Speaker, the activities that constitute offense under the law are spelled out in A to E. But something that is very important to cult activities is not captured under this section, and that is sponsorship. Most of these cult groups have their sponsors. So I expect that act of sponsorship, encouragement of cult activities or promoting it is also be captured under Section 3. Further from there, Mr. Speaker, Section 10 of this law still contradicts in its narration the title of this bill to make it go beyond campus. Because in the expression, in the provision for Section 10, there is repeated use of premises in any part of the state. Premises means a building and appurtenances, or building and outbuilding. But cult activities, as we have witnessed, as we have known, are now expressed with impunity on the streets, in the villages, at markets, wherever they choose to exhibit their excesses. So we cannot limit the jurisdiction of the offense to premises. But I think that in that case, Mr. Speaker, the issue premises in any part of the state, the "in" could be removed to read premises or any part of the state so as to enlarge the jurisdiction, so that we don't limit the jurisdiction of this bill. Mr. Speaker, Section 12, rustication of suspected students. Mr. Speaker, much as it is good to rid the campus of cultists, I see this Section 12 as a trap that can be used for any outspoken student on the campus. Section 12 talks about the charge of cultism pending investigation. Suspension to any student on campus is punishment. An allegation, no matter how strong suspicion is in law, it cannot grant conviction. You have to prove, since it's a criminal offense, that the person has actually committed the offense. So if somebody is alleged and that person is suspended, the person has been serving punishment before the person is called back for investigation. What if a very draconic authority in our institution label a student, suspend the student, and does not visit the investigation or conduct it on time, and the person misses a term? I think alleged student should be investigated immediately and suspended and further punished and rusticated if and when found guilty, so that you don't punish a person before you listen to the person. There won't be fair hearing in such a situation. Lastly, Mr. Speaker, Section 13 makes punishable anybody in fiduciary relationship who encourages cult activities on campus. Mr. Speaker, I think this section should also be expanded to include parents and guardians of of anybody arrested for cult activities. Because events have shown that most of these students, most of these persons engaging in cult activities live under the roof of their parents, who may have had knowledge of their criminal activities but are aiding them. Some of them will go to police station to seek their bail, knowing that they are cult involved. So, Mr. Speaker, what is good for the goose must be good for the gander. If somebody in fiduciary relationship on campus is found liable, parents and guardians of anybody arrested in town, once the investigation reveals the connect, they should also be found liable. Sponsors of cultists should also be found liable. Mr. Speaker, these are my observations on the bill. But on the whole, I think it's a bill that we need now to make our community peaceful and to promote law and order, particularly public peace. Thank you, Mr. Speaker. I support the bill.
Honorable.
Thank you, Mr. Speaker, once again. My colleague, good afternoon. Mr. Speaker, this bill is very, very important and relevant. But I think it's not as comprehensive as expected, because when you look at the spirit of this bill, it looks more as if gangsterism, cultism is limited to our educational institutions. But today, it has gone beyond that. Drivers, tailors, artisans, they are now cultists. Just like what Honorable Agumbiade said, it must not be limited to school. We have those who are accommodating them. The landlord who knew these guys are cultists and accommodating them. What about the tenants that will bring his colleagues that belong to the same trade and come? Just yesterday, Mr. Speaker, 2 days ago, Mr. Speaker, they perpetrated another crime in Shomolu that all the vehicles on the roads were smashed because they were having what they called 8 to 8 day celebration by the so-called Aye fraternity. Mr. Speaker, the bill is supposed to go beyond this. It's supposed to talk about society at large, where every person, irrespective of his social standing, belongs to any cultist association, should be dealt with summarily. And when you look at Section 2.3, I saw that penalty has not been punitive enough to serve as deterrent. If you are a member of a renowned cultist, or you are a cultist and you perpetrated a crime, and the penalty is just talking about 7 years, and those that will just be prospecting other members will go for as high as 15 years. What's the consistency of that bill? I think somebody who is a member of that association and has perpetrated crime should have a more punitive penalty that I look at an average about 21 to 30 years. So by the time they are coming back, they would have been old enough not to be useful to the society. Mr. Speaker, even from there, they talk about Section 16, power to arrest, which was limited just police and any other person. But today we have our neighborhood safety corps, and we just passed the amendment bill that talk about Amateku aspect of it. And I know they are even more important, more instrumental to arresting this issue of cultism. Because, Mr. Speaker, some of these police are even members of this cultist gang we are talking about. So why will you not make a cultist to arrest a cultist? But when we have a more potent arrangement in terms of security, I think it should not be limited to police and any other person. I think neighborhood safety corps should be included. And finally, sir, this bill is very germane, it's very important, and I think it's going to nip in the bud all the nefarious activities of all these cult gangs. Thank you, Mr. Speaker.
Honorable at the back.
Thank you, the right honorable Speaker.
Okay, can you leave this?
Yes, sir. Distinguished colleagues, I want to lend my voice to this bill too. Like what Honorable Lowo just said, I believe the bill is not that comprehensive enough, because when we are talking about the activities of the court in our society, it has gone a long way, and we have a lot of challenges. I tried to read from the section 1, the interpretation. I saw it was written, some of those things, the person means a natural person, a juristic person, or anybody of person, corporate or incorporate. But by United Nations Convention, an adult is 18 years. But if you see what is going on within our society, especially when this pandemic started, then you discover that most of these boys are minors. 11, 12, 13, 14, 15, maximum 21 or 23. So this bill must be able to have something to deal with such. And when that thing happened, especially in our area, then we tried to do some investigations. We discovered that most of those beggars, especially those sitting along the road, out of 40 or 30 of them, average of them always have pregnancy. Who are those people impregnating them? And they deliver those children. Those boys those boys they gave birth to, you discover within 10, 11, 12, 13 years, because they live within us, they speak our language. So most of those boys are recruiting them to attack. They are initiating them. So the bill must provide not a provision that we now go and take them to recreation or something center that they will not be filled. You must be able to. Those are where those things started. So I also in support of the bill. So I want us to look into that. And as been said by the majority leader the other time, the principal offenders, bad parenting, those parents must also be prosecuted if found guilty. I love the bill, but I want us to make sure that we make it more comprehensive so that we'll be able to take care of most of all those things that we mentioned. Thank you, sir.
Honorable Majid.
Good afternoon, Right Honorable Speaker and my fellow colleagues. The bill is a good one. It contains about 19 sections, but I would like to talk on section 5. It reads thus: compelling a person to join unlawful society, and it proposed 15 years. I'm of opinion that 15 years is not enough for this kind of offense. We should look for a way to eradicate this menace from our society. It is on this note that I submit 25 to 30 years imprisonment for section 5 and 6 respectively. Furthermore, section 13 also talks about protections of the courts and act of courtesy. I think we should generalize it. We should not limit it to our learning institutions alone, because 60 to 70% of the young peoples and the promising career are truncated in altars of courtesy. I've seen a case where organizers, mechanics, bricklayers, etc. are members of this court. A case of Bado boys of Ikorodu and 1 million boys. Are they from our learning institutions? The answer is no. We need to generalize it. You don't need to limit it to our learning institutions. It is a time we must rise as a society, as representatives of the people, to protect these young ones from destruction, protect the citizens from the violence, and ensure safety of lives and properties in our dear state. I so submit. Thanks.
Honorable Isha.
Thank you once again, Mr. Speaker. First of all, I would like to draw attention to the fact that this bill has been presented to us as if it is a new bill. I think the title should read an amendment bill, because there exists a bill which is Cultism, Prohibition, Law of Lagos. There exists a law, Chapter C-18. So this should be an amendment bill, and that is proven in Section 18 because there's a repeal clause there whereby that particular Cultism Law 2015 is being repealed. what I observed in this law is to try and expand the scope of the existing law from just an institution to the outside society, which is why they have brought in the, what did they call it now? The unlawful society. But I think, as some of my colleagues have already observed, the law, the bill falls short of its own intendment of trying to harmonize what is happening in the outside world and in our institution as one law. For instance, the only definition you have here is the definition of cultism is restricted to the higher institution, while unlawful society was not defined at all. Also, in the area of the repeal, I think in the criminal law, there's a repeal of a criminal law of Lagos State, which is repeal of section 42 and 43. I think it should go beyond that, because in the criminal law of Lagos State, the unlawful society starts from section 40, which defines what an unlawful society is, goes to section 41 all the way down to section 43. So we also need to pay attention to that. But by and large, I think it's a welcome development. Law is made to ensure that we don't degenerate into the animal kingdom, and cultism is something that we need to guard against, especially with international information that the terrorist world is trying to get into Nigeria, and this will be a fertile ground for them to capitalize on. So we need to nip it in the bud, and as lawmakers, this is the time to do it. Thank you.
Yeah, Honorable, good evening.
Thank you once again, Right Honorable Speaker. Well, I think Honorable Shah has almost captured my main concern in this law. That is the issue of the criminal law aspect of it, which has been in existence before now. But the only aspect that I will really concern myself about is the occurrences of all these on this cultism within the primary schools. So, you know, if you are not aware, it's something that is very rampant in primary and secondary schools, and they are underage. They are underage, and there is no way we can really be talking to the criminal code without really talking about rehabilitation. You know, how we can really manage that situation, because they will get there. That is just my area of concern, because if we leave that area captured, then we take care of those that we have seen as the intended criminal today, and those ones we grow up to replace them tomorrow. So that area must be addressed. And lastly, sir, the issue within the university campuses or the tertiary institutions should also not limited to rustication. If they are found guilty, they should be prosecuted because they are of age. And I think they too should face the side of the law. Thank you.
Honorable Desmond.
Thank you, my right honorable speaker. Good afternoon, colleagues. Mr. Speaker, I believe this is a very welcome development. It's a long time coming, sir, because the situation, as many, if not all our colleagues have said, that it's is an issue that should have been dealt with a long time ago, and it has surpassed what the bill recommends as it is. Mr. Speaker, you've always been one who has always spoken from the home front. This bill must be more robust than it is if we want to take the situation of unlawful societies and cultism very seriously. This bill, I'm sorry to say, sounds like child's play. This is a 10 years ago bill, not what exists today. If we must take it seriously, we must couch situations where people are cajoled, people are forced into these cultist groups, and provide an avenue where, or for instance, create an agency, department, a very serious team or unit that can deal with cultism in not just institutions but around the state, where you can report in confidence, where you can run to, where cultists who don't want to be cultists anymore can go to, and they can get respite. Also, orientation. Our homes. We must be able to create orientation from birth, because if not, we'll continue to have this thing. It's already in primary schools. So how can we deal with the situation? The ministry or a unit for orientation of our homes, how our parents should take care of our kids, our wards to take care of our children, should also be addressed. If we must take the situation very seriously. Remedies also to cultists. When they've served penalties and gone through their punishments, how can we rehabilitate them? All of this must be couched in this bill so as to have something more robust for the society. Thank you, sir.
Honorable Eshinoku.
Thank you, Mr. Speaker. I also join my colleagues in supporting this bill. And however, as you know, this bill speaks to the threat to our peaceful coexistence, either in our villages, towns, or cities, or even in citadel of learnings, or even primary or public schools. So that is why I will join my colleague in supporting this bill. However, in supporting the bill, I have some observations. I want to, the definition, so to speak, is too broad for me. When you look at section 2.3e, 2.3, it said, any person who does any illegal act which may probably cause a breach of peace or disturb the public peace or conduct himself or herself in such a manner as to threaten life and property. What I'm saying is that ordinary assault, affray, public fighting, three people fighting, even three people doing race track illegally can be captured with this bill. I think that 2.3e should be expunged. Section 3 also is talking about presumption of guilt. It says that, with your permission, any presumption of membership of unlawful society, any person who attends a meeting of unlawful society shall be presumed until contrary is proven to be a member of that society. Same thing for 3.2. However, when you look at the Constitution, section 36.5, sir, with your permission, I will read. Every person who is charged with criminal offense shall be presumed to be innocent until he is proven guilty. So this is a clear contradiction of the Constitution of Nigeria. Also, it also contradicts, as it were, section 138 of the Evidence Act of the Federal Republic of Nigeria. So that section should be expunged. Section 5 and 6 to me are duplicative. They are just talking about the same thing. Compulsion, one is talking about compulsion with violence. I think they can be merged. Or one should talk about the inducement. If you induce either as a lecturer or whatever, any student or a member of the society to join a cult group, you shall be so fined. And like some of my colleagues did mention, section 2A and 2B, where it is specifically mentioned that within a premises should be expunged to mean any part of Lagos State, because like my colleague that mentioned, cultism thrive on our streets, on our roads, and not restricted as it were now to the four walls of learning or institution, so to speak. Also, when you look at section 11.3, it says, it's talk about prescription. It said that after the commencement of this bill, shall be proscribed, all these society shall be proscribed. That is too futuristic to me. I guess if it can be more elegantly drafted, that it should just be, I should just read, is hereby proscribed. Immediately after the signing of the commencement of this law, they are proscribed forthwith. Section, also, sir, section 11.4 talks about registration. Also talks about subject to provision of section 1, association of society not duly registered with the authority of the institution is illegal and will be immediately proscribed. Sir, this is a clear contravention of section 40 of the Constitution of the Federal Republic of Nigeria. What does section 40 says? With your permission, every person shall be entitled to assemble freely and associate with other persons, and in particular, he may form or belong to any political party, trade union, or any other association for the protection of his interest. Sir, I want to say that while we should frown seriously at any act or association that would disturb public peace, we cannot, in spiting our face, cut our nose. We must not try in any ways whatsoever to disturb social interaction and any act that will engender human evolution. Thank you, Mr. Speaker.
Honorable Secretary.
Thank you once again, the Right Honorable Speaker. I just want to start with the issue of interpretation. On the second page, the students means, with the permission, any person admitted into an institution in pursuance of a vocational course or training. It may interest this humble, distinguished house to know that there are several primary school students that are involved in cultism. And that one is not covered in this area. The issue of cultism is a very serious challenge you have. But the major challenge we have in Lagos State and even Nigeria in general is not lack of law. It is implementation. It is prosecution. It is the issue of, applying the law. The law enforcement agencies are not there. Of course, we have an existing law on the cultism, as shown on page on section 18, the cultism prohibition law, C118. So this is just an amendment as recognized by my colleague. So it's not that we don't have law. We can be making laws every day, but how do we empower the security agencies to carry out these laws? So that is one challenge that I noticed. But by and large, this is a very germane amendment or bill that we need to, embrace all the issues that have been raised by my colleagues, because it's everywhere now. The issue of course is everywhere. And it can become a major menace in our society. So I want to I urge my colleagues to let us treat this as a very serious matter, and all the areas that have been mentioned to be addressed. Thank you, sir.
Honorable Toby.
Thank you, Mr. Speaker. Well, distinguished colleagues, cultism is a menace that is causing disharmony within our society. So any bill that we stamp it down, is highly welcome and supported. However, we must know that present-day cultism, we must separate it in totality with those that has to do with our ways of life, our culture. In most cases in Yoruba clans, we know there is what they call Ushugbo. They call them the prime minister of all those days. When nobody is emanating from any clans, it's this Ushugbo that prepare. So, and most of those ones they use them. Are trying to outlaw it. So I feel life imprisonment may come to replace death sentence. Then if you look at section 7, subsection 2, where they said any person who, with the intention to compel people, they said serve lifetime of a term lifetime. Whereas those who compelled using harms were earning 21 years imprisonment. So those who have intention, who have not carried it out, we are sending them to life imprisonment. While those who have used force to compel people, we are sending them to 21-year imprisonment. I feel this must be, maybe the other way around. So those who have intention and those who have really carried out that threat should earn more life jail than 21 years imprisonment.
Well, Honorable Tom, thank you. We just have to move on. It's like we have gotten to a stage we are repeating what has been said in the past. Honorable
Okay, sir.
Nureni, do you have anything different from all that? Oh, yeah, go ahead.
Thank you, Right Honorable Speaker. My honorable colleague, what I just want to add, at least, I found useful section 8, 9, and 10. But section 7, sir, there are some people, you cannot stay with your two eyes on the street. But there are some people now in the street that used to sell for them. Indeed, as if they are selling drink. For all these boys, they used to stay there. Please, I want them to be included in section 7, sir. So, at least they too can be punished for that. Thank you, Mr. Speaker.
Honorable Saka, do you have anything different? Or who has the light? Yes.
Thank you. Thank you, Mr. Speaker.
Do you have something different for all that?
Yes, sir. It's regarding Section 9, sir. Regarding the protections of defense of compulsion. We just need to add a bit more to that section, sir, regarding people taking care of people who've been indoctrinated into cults, so that they can protect themselves so they're not prosecuted alongside the person who's been indoctrinated to the cult. In case if we have an old woman who's taking care of a younger grandson who's about 14 who has joined the cult, there's nothing in Section 9 capturing her defense as opposed to something capturing only the young man's defense. He has 14 days to explain everything, whereas the parent or the guardian of the person doesn't have such privileges, sir. That is my submission.
Thank you, Honorable. I will have something different.
Sir, thank you, Mr. Speaker, sir. What I have in mind is just to call our attention to the issue of cultism, as rightly put by Honorable Yishao, that there have been existing cultism prohibition bill. So what I will submit, without wasting our time, is that we should harness the previous bill with this one that we have, so that we'll have a creative as well as a well-crafted one. Thank you, sir.
Yeah. Well, I thank you for all you have said. Without taking much of our time, I think Honorable Tom has been able to emphasize that area that we should be able to differentiate in the type of cultism we talk on the streets and those ones that have been around for quite some time, so that we won't have, solve one problem and create another. We have the Ogbonis, we have the other, the school judge, and all of them who have been practicing this cultism as a form of religion. So I think the committee has to look to that area, because the title given is an open one, generalizing without reservation, and also the way weapons are being defined or interpreted in this bill needs to be looked into. We have hunters, in societies where the hunters practice their own trade, and they go about with guns and all sorts. You have the bushers also, who have kind of society where with their cutlasses and knives, performing their own daily profession. So we have to look at the way and manner in which weapons, have been described in this bill, so we won't create opportunity for whom are ready to extort anybody in this law. So, and the existing law with this bill should be looked side by side, as said by Honorable Laiwola. So that's, we just take the good things in the new one and add it to the existing one. But the way and manner which cultism and society have been discussed or defined should be seriously addressed. And the area of what is it called? Freedom as expressed in the Constitution, against what the bill is suggesting, should also be addressed. I think with this, the bill is hereby committed to ask Committee on Judiciary to report back in 3 weeks. Now, before we go, I think there's one other thing that's very important that we need to look into, and that has to do with the last bill, which the House has also amended and sent for accent of the Mr. Governor, which is yet to be back, and it's over almost 30 months. So, and in view of the autonomy being granted, I think we should have a bill that also follow the same pattern. So it is an opportunity for us to also take this bill again and address whatever we need to address. Honorable Lobo, your line was on.
Yes, I was just about, Mr. Speaker, thank you for bringing that to the fore. Because I was wondering, if you talk about autonomy as granted by the President, Mr. Speaker, I have to thank you and other speakers of the Houses of Assembly that actually presented your case before Mr. President, and he eventually approved it. But the bill we are talking about is not consistent with the spirit of that approval. Because when we are talking about autonomy, we cannot have semi-autonomy. It's supposed to be total autonomy. But when you look at that last bill, and you juxtapose that with the autonomy that has been granted by Mr. Speaker, then there will be more deficiencies. So I reason with Mr. Speaker, it is high time we looked into it. Issues that borders on promotion, transfer, and stuff like that. Do we need to still go elsewhere where we're talking about legislative autonomy, judiciary autonomy, and executive autonomy? They're supposed to be independently related, not that there will be confusion again. So I reason with Mr. Speaker, and it's high time we did that so that we can get a robust, comprehensive law at the end of the day, which will capture the spirit of that approval. Thank you, Mr. Speaker.
In the light of this, there will be another committee to be headed by Honorable Nohim, Honorable Desmond, Honorable Akondi, Honorable Ajani, Honorable Laiwala, Honorable Setonji, to report back in a week. Is to take up the last amendment bill and report back in 1 week. Majority Leader.
Colleagues, we have dealt with all items listed for deliberation today. And upon that, I have the approval of the Right Honorable Speaker to move that this House adjourns till Monday, the 17th day of August at 12 noon. I so move.
Honorable Muredi.
Right Honorable Speaker, I rise to second the motion as moved.
All in favor say aye. Those against no. The ayes have it. This House stands adjourned till Monday, 17 August 2020 at 12 noon prompt. I rise.